I left out, as I did last year, a couple decisions that were really headline making, but don't have a lot of future practical significance. The obvious example is the Soto versus Bushmaster Firearms case about allowing a cutback claim to continue for some of the families of the victims of the Sandy Hook massacre. Unusually this year, I guess this is only the second year I've done it, so I don't know, not unusually, but this year there were a couple cases that came out in between me giving this presentation to the Fairfield County Bar Association in last month and today, that had they come out last month would have been on the list. I sent around actually blast emails about both of them. One was the DeMond case that Rachel and I had, and the other is the McGee Geriatric Services case about proving fraudulent transfer of assets when somebody is attorney in fact for the actual debtor. That might be the most important case of the year in terms of what it allows you to prove, and also I think the most important case of the year for any attorney that manages somebody else's assets. You really have to think about your conduct. All right, so, and as always, interrupt with questions. You don't have to hold your questions till the end. New Haven, Westport, if you have a question, just throw something at the camera or send up a flare or something. So, without any further ado, number 10, sorry to keep you waiting. This is an independent party of Connecticut versus Merrill. I'll say this as an aside, there's a whole interesting election law discussion in the case, but that's not what I care about. I think not what non-election law petitioners care about. So the bottom line is that a supplemental briefing order stops the 120-day period for a decision under 51-183B, and this is the most critical point, the 120 days start over after the supplemental briefing or argument. As for any of you that, and all of you, most of you do, the 120-day rule is one of the things that trial lawyers I think hate the most, because either you're waiting around wondering when the judge is going to rule, you get some postcard decision towards the end of the 120-day period, or you get requests for an extension. And I've been told that it's something that trial judges hate too, because by the time they turn, they're busy, and by the time they turn to a decision, writing a decision, they've forgotten what the case is about. Anyway, so the case generally involved an election dispute between the Waterbury and Danbury factions of Connecticut's independent party. And there's a long, tortured history about how the independent party came to being, how it got hijacked. If you're interested in read the opinion. It's some fascinating reading. So, bench trial in October 2017. They have post-trial oral argument March of 2018. 116 days later, the trial judge, who shall remain nameless, but whose name rhymes with heck, leaves the lawyers a voicemail asking for a 60-day extension and some additional proposed orders. Basically, she brought up the political question doctrine. Can I rule on this, or is this a political question that's outside my jurisdiction? The defendants submit orders and consent. The plaintiffs refuse to waive the 120-day period, and that's the next day. The day after that, so day 118, the court orders supplemental briefing anyway, and schedules oral argument for August 3rd, which would be day 133. And on day 151, the trial court issues a decision. It's not a political question, and the defendants win. So the plaintiffs appeal. They make a lot of election law claims, but again, the issue that I think is important is the 120-day issue. The Supreme Court says if a trial court properly, and properly is important, I'll get to that in a second, but properly reopens a case during the 120-day period, the 120 days start anew at completion of the proceedings scheduled on the date they were reopened. In this case, the plaintiffs didn't challenge the propriety of the supplemental briefing order. So they didn't say the judge shouldn't have done what she did. And so they were out of luck. In spite of the language of the statute, which says the consent is necessary, and in spite of a long line of cases that says if you want to preserve your objection, you have to do so expressly. If you're silent, it means you consented. So in theory, at least, the plaintiffs did everything they were supposed to do under existing precedent to preserve their objection. So I think this is very significant for trial practitioners, right? It is significant in that it gives you a roadmap, what you need to do, what you should expect if you don't want to waive the 120-day period. And I think it invites some future litigation about ways to get around the holding of this case. So the big thing here, one of the big things here, was that the political question doctrine is subject matter jurisdiction. So it can't be waived, it can be raised at any time. The case doesn't say, and I think this is going to get litigated, what would happen if the judge raised a question or supplemental briefing on a non-subject matter jurisdictional issue, and somebody then properly objected to extending the 120-day period. So, I think one of the things that the decision also hems and haws about is, what do you do about judges who are just generally dilatory, or maybe aren't quite doing this in good faith? And so this decision sort of goes back and forth. There's a footnote 14, which basically says, judges, listen, we know you're busy, but you really got to get your decisions out quickly. But then there's some language in there about, a trial is not complete until the court has the materials necessary to a well-reasoned decision. Well, any judge, if they need more time, can figure out things that they might need for a well-reasoned decision. So the court, I think, is trying to strike a balance between those two competing imperatives. Anything before I move on? Okay. Number 9, language that everyone here can easily understand. Bonus points if you know which famous political figure I'm quoting. That's Ventura versus East Haven. And this is another in a long line of Supreme Court cases narrowing the scope of municipal liability for conduct in the course of some of these municipal duties. So, bottom line, whether a statute, regulation, ordinance, policy imposes a ministerial or discretionary duty is a question of law, not a question of fact. I would say overruling the Supreme Court is abrogating the opposite holding in about a half dozen cases, which is said it's a question of fact. The big deal there, of course, is it used to often go to the jury, now it won't. So the law is now that it's a question of law. So for all of you here last year, we talked some about Brooks versus Powers, the lady who's out in the field watching the game by light. These cases always have tragic but really fun facts. So here this is in East Haven, which by itself just opens up a whole world of possibilities for police conduct. And so an East Haven police officer goes to McDonald's parking lot because there's a report about a domestic incident. He finds a van there. No one has a license. The van's uninsured and unregistered. The officer doesn't learn that it's uninsured and unregistered until later because he mistakenly radioed in the wrong license plate. In any event, the officer takes the driver, who was the aggressor, home, doesn't take his keys away, doesn't have the van towed. I'm sure you can imagine what happens next. Walks back to the McDonald's, gets in the van, and hits an 18-year-old high school student seriously injured. So the jury rejects an immunity special defense, worth $12 million, gets reduced to $6.2 million by the trial judge. The appellate court reverses, says there was no clear ministerial duty for the officer to have towed the owner's van. And so it goes to the Supreme Court. So the big holding the Supreme Court makes is that it's a question of law, overrules, as I said, the contrary language, and abrogates the holding in a bunch of cases that have made it a question of fact. And in this case, interestingly, directs judgment in favor of East Haven. So the toll rules had some conflicting language in them. What the Supreme Court said is, we can read this language just as well as a trial judge or a jury could. And what the language really means is that the police have discretion whether to tow a vehicle, but once they decide that, the towing company has no discretion. If a police officer tells them go tow this vehicle, they have to do it, and that's a ministerial duty because they're acting as an agent of the town. In a minute, I will explain why I think that's wrong. But that's the bottom line. But the real bottom line here is that it's a question of law. So what does this all mean in the bigger context of municipal immunity case law? Well, listen, as I said last year, You've got a Chief Justice who was Assistant Corporation Counsel for the City of Stamford. You have another Justice who was the Corporation Counsel for the City of Stamford. You have a Justice who was Assistant Attorney General for 23 years. It is a great time to be the government when you're arguing in the Supreme Court, and especially with the municipality. So this is further evidence of the court's pro-municipal bent. By making it a question of law, what they are saying is, hey, this can be decided on summary judgment. Move for summary judgment more, and trial judges decide it more on summary judgment. And rather than just in this case saying, you know, in this case, the appellate court was right, they changed the legal test to say that give trial judges a really clear signal that you don't need to wait, you know, for trial for a directed verdict or anything like that. You know, and in this case, I mean, if you look at the facts, right, there was testimony by the East Haven police officer who had been designated as the person with most knowledge that unregistered vehicles are routinely towed, that he personally never let anybody drive off in an unregistered vehicle following a traffic stop, and the general rule in East Haven was, to quote him, tow and impound. I would guess that's a general rule in most municipalities. It's a nice source of revenue, right? But to me, that says issue of fact, right? Because that says just get to a jury at least about whether or not that's a municipal policy that is discretionary or not for the police officers themselves. Everybody does it as a matter of practice, and it's known to be a general rule. Supreme Court disagrees, again, narrowing the scope of municipal immunity. So it's on my to-do list. This is State versus Daniel B. So the bottom line, is anybody here? Nobody here does criminal law. In any event, this is not just a criminal case, although that's where it starts. So whether conduct is a substantial step for the criminal intent statute focuses on what a defendant already has done, not what he has left to do in order to complete the crime. I'm taking, I think, for some of us, at least all the way back to crim law, first year of law school. But so the defendant's going through a contentious divorce, and he asks a friend for help. The friend sets him up, and he ends up meeting with an undercover cop who's posing as a hitman. So, and if you want to read tragic farce, the Supreme Court opinion has a verbatim transcript of the recorded conversation between the cop and the defendant. But anyway, he agrees on a price for killing his wife, doesn't pay. He shows the cop her photo, gives him her name, address, and work schedule, and he says, let's make it look like a carjacking, and I'll make sure that I'm taking care of our kids. I'll pick them up from my wife's sister's house and have them till I have an ironclad alibi. The moment he steps out of the car, he gets arrested. He gets convicted of attempted murder, among other things. The appellate court rejects his sufficiency challenge and says that he did enough with the stuff I just talked about to be a substantial step. So, the opinion, and there's a dissent too, it's really fascinating to talk about in a minute, look at the interplay between the justices. So the opinion says, in my mind, two contradictory things. It says, first, the substantial step inquiry focuses on what the defendant has already done rather than what he has left to do. And then it says, what is left to do, however, not completely irrelevant to the inquiry, and the defendant is free to emphasize what he had left to do. If I were a lay juror, right, and I got told those two things, which is now the law, I would be confused as hell, right? Because to me, the legal nicety of not completely irrelevant versus what it's supposed to focus on is a tough metaphysical concept to keep in mind. And I really, I expect a lot more litigation about, well, how exactly do you instruct juries in light of this? So then in this case, the defendant's discussions with the cop and other acts, like getting her picture, like setting up an alibi, were enough to constitute a substantial step for murder for hire. That was not, by the way, although it may seem so in light of the facts that I just discussed, not a completely ridiculous argument. There's a line of cases about the difference between solicitation as a crime and attempted murder as a crime. The dividing line usually being, have you paid the hitman? You paid the hitman, it's attempted murder. You haven't paid the hitman, right? It's solicitation. He wasn't charged with solicitation. The Supreme Court took the sort of surrounding other conduct to get over that hurdle. So the really important thing, and so I talked about attempt versus solicitation. The really important thing for non-criminal law practitioners is the majority versus the dissent. So the majority is Justice Kahn, the dissent is Justice Ecker. And what you see are three sort of real dividing lines between them that sort of mark some of the fault lines on the court. So Justice Kahn writes a very practical, jury-centric opinion, a lot of black letter law about sufficiency challenges, about deferring to the jury. Justice Ecker writes a very academic opinion, talking about, citing cases, federal cases mostly, about how a judge can step in even if there is just a little bit of evidence that supports the guilty verdict. You see a judge who's state court focused. Justice Kahn cites only state court Connecticut cases in her decision versus Steve Ecker, Justice Ecker, who was a federal court practitioner, not entirely, but largely, clerked for John Newman. He cites almost exclusively federal cases in his opinion. And as I said, jury-centric versus judge-centric, right? Justice Kahn is all about a jury's prerogative to decide issues of fact, decide guilt or innocence. Steve Ecker, Justice Ecker, is much more about the power of the judge to decide. I think this is a divide that's going to play out a lot on the court. I will say, as an aside, Rachel and I got that decision in Vermont, and the shock to me was that Justice Ecker wrote a decision affirming a directed verdict against the plaintiffs, wrote a pro-defense opinion. So expectations about justices can change, but here I think you're going to see one of the big dividing lines between quite a few members of the court, Justice Kahn, Justice Mullins, Chief Justice Robinson, who tend to want to write narrow, fact-bound opinions, and Justice Ecker, who's a much more sort of ivory tower guy. Number 7, don't go there. This is Pelosi versus electric vote. To my shock, this is actually one of the Supreme Court decisions about collateral estoppel that made the top 10 this year. I guess I'm barred from bringing up any next year. Collateral estoppel. Thank you for the mention. So collateral estoppel bars a party from relitigating causation, even if the first tribunal did not expressly state it was applying the same causation test as the second tribunal. So just as an aside, causation happened to be the issue here. This doesn't just apply to causation. This applies to any test that the first tribunal and the second tribunal both have to apply to a similar issue. So this happens to involve workers' compensation. The plaintiff's husband died of lung cancer. He's a heavy smoker, but he also had a lot of asbestos exposure working in electric boat. He files a workers' comp claim, and he files a Longshore Act claim, which goes to a federal administrative law judge. They try the Longshore Act claim first, and it's battle of the experts about whether or not the asbestos was a substantial factor in causing his lung cancer. And the ALJ credits the plaintiff's expert, who in his report said asbestos exposure was a substantial contributing cause. The administrative law judge doesn't say what causation test he's applying. The administrative law judge just says, I credit the plaintiff's expert, and recites portions of the expert's report. And the comp commissioner, when the case comes up in the comp context, refuses to collaterally stop electric boat from relitigating causation because he says the tests are not the same. The review board reverses, and the Supreme Court affirms. So the specific holding is your electric boat was collaterally stopped from challenging compensability because the administrative law judge had made a finding about causation, about it being a substantial factor. And so the board did the right thing, which I think applies in the context outside of workers' comp. That is, it didn't just look for some talismanic words or the recitation of some rote standard. They looked, what legal standard did the administrative law judge actually apply in his decision? And as it was actually applied, it's the same as in the second proceeding. And here, right, if you read the administrative law judge's opinion as a whole in light of the testimony he relied on, he basically applied the same test as he applied in workers' comp, substantial factor test. There's also an interesting footnote. Some Connecticut trial judges, especially written opinions, saying offensive collateral estoppel is disfavored. I don't like using it. Supreme Court cleared that up and said as long as the same parties are involved, offensive collateral estoppel is a perfectly valid doctrine. There should be no hesitation in using it. All right. So as I said, there's a couple important takeaways here. One is it applies to other contexts. Right here, it happened to be a Longshore Act claim, workers' comp claim. But there are often situations, workers' comp and just tort actions being a good example, where the same set of facts get relitigated in two different tribunals for two different sorts of compensation, right? There's no reason why Pelosi doesn't apply in those cases. As I said at the start, it applies to other issues besides causation. If you just take negligence as an example, right? If you have a previous finding of a breach of duty, and it doesn't really say what the legal test is, but it's basically the same as the second tribunal applied, I think Pelosi applies there. And last, as I said, I think this, I don't want to call this an expansion of collateral estoppel, but it certainly is a broad use of collateral estoppel to look at what the implied holding of the first tribunal's decision is. And so to the extent that issues come up with trial judges hesitant to use collateral estoppel, this is a good case to make use of to remind them of its value, efficiency, practicality, giving parties a chance to have a final determination of the issue. Anything before I move on? Everybody alive still there? Westport, New Haven? Guys? All right, so, and this is, I put this one in for Matt specifically. 4 minus 1 divided by 3 equals 1. I think, a long time since I did any math, I think that is a correctly written equation. And this is Katie versus the Zoning Board of Appeals of Berlin. This has some very interesting zoning and municipal law implications, but it's also an important case because of what it says about one of the most important members of the court. Let's start with the case itself. So, reconfiguring the boundary lines between 3 formerly conforming lots to create 3 currently conforming lots is not a subdivision in the meaning of the subdivision statute, and therefore you have to go through the whole rigmarole of the subdivision application process. The gentleman had 3 lots of property. Lot 1 actually used to be 2 lots. In 1986, the previous owner had combined a conforming lot with a non-conforming lot to make lot 1. And lots 2 and 3 were pre-existing conforming lots, but they didn't conform any longer to Burlington's regulations about development. Smart developer, what does he do? He takes a little piece of 1 and adds a little bit to 2 and adds a little bit to 3, so now that all 3 are big enough for development on. The zoning enforcement officer, unusually in my experience, Matt, maybe you've had different experiences, approves what the developer did, writes a fairly detailed decision explaining why she was approving it, and the ZBA upholds the decision and said that these are 3 pre-existing lots. They were all in existence before the current zoning, the subdivision regulations, and they could be reconfigured as needed by the owner without needing subdivision. And so guess who this goes to when a neighbor appeals? Matt, who does this go to?
I'm sorry, what do you mean, the ZBA, is that what you're saying?
No, what judge ends up hearing this?
Oh, Berger?
Yeah, you bet.
Oh.
Judge Berger, in his little fiefdom in Hartford, spans the entire state. And so he reverses the ZBA for 2 reasons. One is he cites a case called Goodridge, which has what he calls the minor lot line adjustment rule, and says this is not a minor lot line adjustment, this is a major lot line adjustment, taking property from here, putting it there, and so that's a subdivision. And the topography, in his words, of the lots differed, so this really couldn't have just been a combination. And he gets reversed. The holding itself is pretty narrow, and that's important, narrow and there's not a lot to the holding. That's important for a reason in a minute, but so it says, listen, 8-18 is plain, right? If you want to have a subdivision, you have to divide a lot into 3 or more lots, right? Just changing the dimension around of 3 lots isn't a subdivision, isn't a division, and it doesn't qualify. And it sort of limits, I would say maybe reverses sub silentio, the Goodridge case, to its negative holding, right? So just because a minor lot line adjustment doesn't equal a subdivision doesn't necessarily mean that something more than a minor lot line adjustment is a subdivision. And so, Goodrich is really out there saying, listen, it's a minor lot line adjustment, you don't even get to first base. Okay. So, why does this case matter? So, I'll do the bottom two first. So, for developers and zoning officials, this is an important decision. Important both for its facts and for, I think, what it says about the right way to go through the administrative process. You had a CEO, like unusually in my experience, wrote a thoughtful, detailed decision. She looked at the history of the property, she cited some law, she did things that 99% of CEOs do not do. And the ZBA deferred to her, as they are supposed to, because she did her homework and was careful. Right? What does that say for developers and local zoning officials? If I was a developer and I had a good lawyer, right? I would write a letter to the zoning enforcement officer and write her decision for her, or his decision for him, as the case may be. And say, hey, listen, look what the Supreme Court said, here's a way where you don't have to have this coming back all the time, we get slapped down by the ZBA or by a court. Maybe leaves open the question, for, again, this is for zoning nerds, how minor really is minor? I mean, are you going to get to a point where some reconfiguration of property is just an end run around them? But the reason why this matters, I think, outside of the context of zoning is Justice Mullins wrote the opinion. And Justice Mullins is right at the center of the court. And I don't mean politically because, as I said before, politics don't really play out in the same way in the Connecticut Supreme Court as they do in Washington. But he tends to want to write cautious, narrow opinions that are deferential to the legislature when appropriate, deferential to other branches of government, deferential to prosecutors when appropriate, but that I think maintains a healthy role for the court in doing its job. And so what does he do in this case? This is a case where the center of the court is all about deference to other branches of government, right? We have local zoning authorities. They, again, Matt trying to laugh at this, they know what they're doing. Sure. Right. They know what they're doing. That's why we have the substantial evidence rule, right? So the opinion emphasizes the substantial evidence rule. And then you see his deference, and again, the center of the court's deference to the legislature, right? The statute says what it says, right? If the legislature wants to change that around or carve out an exception like Judge Berger felt entitled to do, let the legislature should do it. In the meantime, we have our marching orders about following the plain language of the statute. That's what I'm going to do. Right? So for other cases, right, here is a roadmap to how you get inside Justice Mullins' head and persuade him. And with Justice Mullins, I think a lot of the other justices, certainly in that camp, I would put Chief Justice Robinson, put Justice Kahn. Right? I would, on more days than not, probably, I would put Justice Palmer, although he can sort of be all over the map a little bit. Not all the justices are in that group. Justice Ecker's not. Justice McDonald is probably not. But the center of the court is that usually at least the plurality of the justices are very receptive to arguments like this in whatever sort of case it happens. Number 5, where's Henry Fonda when you need him? 12 Angry Men, for those of you that remember that. Smith versus Rudolph. No state constitutional right to a jury trial in suits against the state for a state employee's negligent operation of a motor vehicle. It's a statutory cause of action. It is a frequently litigated statutory cause of action. And as happens, some tragic facts. So a state boss runs a red light, hits the plaintiff's car. The plaintiff sues, represented by a really excellent Hartford attorney, Jay Nelly, for those of you who know. It claims case for jury trial. The defendant, and this is one of the few times I've ever seen this or heard this coming up, moves to strike the case from the jury list. And the trial court grants the motion, there's a court trial. Judgment for the plaintiff, I'll get to it in a minute. Judgment for the plaintiff, $32,000 judgment. The plaintiff appeals. Right? The plaintiff had filed a notice of appeal when the case was struck from the jury list. Probably unnecessarily, but had done it anyway. But got a judgment in his favor and appealed, saying, I wanted my jury trial. Yeah, and in fairness, he probably would have gotten more than $32,000. the main holding. So you only get a jury trial. This first part sort of settled law for common law actions that seek a legal remedy against a defendant who you could have sued at common law in 1818. Right? And in 1818, you couldn't have sued the state at all. Sovereign immunity was absolute. Right? And so, if you want to get a jury trial, when you sue the state under a statute that abrogates sovereign immunity, the statute has to expressly mention the jury trial. It's a very commonly litigated example. The highway defect statute expressly says you get a jury trial. Of course, the highway defect statute then shows how scared the legislature was of jury trials, that they have the sole proximate cause rule and they make sure juries don't go hog wild in these sorts of lawsuits. But here, there was only at best an implication right to a jury trial in 556, so the plaintiff was out. So the takeaway, the first one is just for us appellate nerds. I still don't know how the plaintiff had the right to appeal. Right? He got a judgment in his favor. Right? He wasn't for the amount he wanted, but a judgment in his favor. And he didn't appeal the award of damages, right? If he had moved for an added or got denied and then appealed, that would be one thing, right? But all he appealed was the jury trial. I don't get how this was agreed. Now, I am not the last word on these things. I scoured the decision, the briefs, the appellate record. There is not a single mention, nobody mentions agreement. So maybe I'm just crazy. But what I think this highlights, because aggrievement is subject matter jurisdictional, so if it were in the case, the Supreme Court would have had to bring it up, is that when the Supreme Court wants to decide an issue, sometimes it can overlook certain things, right? Most of the time it doesn't. There are, every year, you can find half a dozen cases where they say the parties haven't raised this, but it's subject matter jurisdictional, we have to, so it's moot, or not a final judgment, or no agreement. But this issue had come to the Supreme Court before in the last couple of years. It's called Rodriguez. The appellate court decided, cert got granted to the Supreme Court to decide this exact issue, and then the parties must have settled because Rodriguez got withdrawn before the Supreme Court could decide it. I think that for whatever reason they saw this issue out there, they wanted to decide the issue, they had their chance, and the parties weren't bringing this up, so I'm nodding no. That may sound too cynical, but I don't see any other way around agreement. In any event, so this puts an end, at least if Jay Melly is to be believed, and when it comes to all things civil litigation, I believe Jay Melly, puts an end to a very common practice, which is these cases were almost always going to a jury and tried to a jury, and nobody said boo about it before. The Supreme Court, in its opinion, said, so what? You know, practice isn't law, right? There's no express right to a jury trial, but you know, it could be a case which took some defendant to have a light bulb go on and say, well, wait a second, let me check the roster of judges, let me see who's likely to actually hear the case. Okay, it's not Judge Wagner, can't be Judge Wagner, but not a judge who award a lot of money, so let's bring the issue up. And so, what's the policy behind this? Right? Judges are less likely to get big damage awards than juries. It's not uniformly true, right? There are some judges who, had their hand right in the purse, but as a general, right, you expect that from judges, right? This is a waiver of sovereign immunity where you get to sue the state. The judicial branch is not blind to the fact that the money that would come to pay for judgments like this is coming from the same pot that pays for the judicial branch to run that makes the state operate. And so a narrow construction of the at least implied discussion of a right to a jury trial in the statute, I think goes to that. So number 4, actually I don't work for you, Browning versus Van Brunt. This, by the way, holds to my rule of only citing one case in the top 10 every year that I worked on. Jeff Costello and I handled this case. And it's a big case in the area of trust law, but also civil procedure. So the bottom line, to have standing to sue for an injury to a trust, the beneficiaries have to allege that the trustee either improperly refused or neglected to bring an action in the first place. So this is, any case like this, big family dispute. So there's a rich gentleman out in Utah who set up an inter vivos trust for his 6 kids, appointed one of them, his ostensible favorite, as the trustee, and the sister looted the trust. When it finally came to light, there was almost no money left, and the beneficiaries turned around. First of all, they got the sister replaced. Then new trustees appointed by the probate court. They turned around and sued the trustee and the trust financial advisor for allowing their sister to leave. They did not first ask the new trustee to sue the financial advisor. The trial court granted the financial advisor's motion to dismiss for lack of standing. The suit against the trustee went on. And I think, as far as I know, it's still going on. They haven't gotten to trial yet. The beneficiaries filed a notice of intent to appeal. They wanted to defer it to the end. We wanted to push it. We objected. So the appeal on just the dismissal of the suit against the financial advisor went up to the Supreme Court of the Trust to file a lawsuit. And there was no allegation of either of those things in this case. No allegation that they asked the trustee at all, let alone that he refused. And no credible allegation that his refusal, the failure to sue, was neglectful. Right? The evidence, in fact, was that the trustee said, this trust used to have $2 million in it, it now has $80,000 in it. Why would it make sense to spend that $80,000 on a lawsuit, right, when it's already been removed? As I said, for trust law, it's important because it clarifies this area of the law. It also, at least implicitly, adopts the restatement third of trust in Connecticut. So we have a trust case, probate case. That's a good thing to cite. And as an aside, it brings up the Supreme Court's love-hate relationship with the restatement. There's about half the time you see cases where they say, we are adopting the restatement, or they cite the restatement, products liability being a good example. Other times they expressly decline to adopt provisions of the restatement, especially the restatement third, which changes a lot of things around from the restatement second. As I think you see some turnover on the court, maybe they'll get more comfortable with the restatement third. For these justices, as I think for just about all of us, we're still all in the restatement second, when we're in law school. That's sort of the formulation of the law you feel comfortable with. The big procedural thing about this is the difference between motions to dismiss and motions to strike. And of course, this gives lawyers and judges fits. When can you file a motion to dismiss? When can you file a motion to strike? And in this case, we argued the case March of last year. August, we get a supplemental briefing order along the lines of, 1, was this properly decided on a motion to dismiss? 2, why? 3, if it wasn't, is it harmless because we would have granted a motion to strike anyways? The basic distinction, motion to dismiss, motion to strike, right? Motion to strike admits all the well-pleaded facts, but you can't state a cause of action under those facts, right? Motion to dismiss, you can get jurisdictional discovery, the court can hold a factual hearing, and it's limited to certain narrow issues, right? So we did all that stuff with supplemental briefs, and then the Supreme Court just said, no, motion to dismiss was wrong. I'm happy that we won, and I certainly don't want to look a winning horse in the mouth. But the Supreme Court's big point was that if it's not pled in the complaint at all, right, then it's proper for a motion to dismiss. They didn't make the allegations, so we don't have to assume that they're true and then move you to a motion to strike. If you read the plaintiff's complaint generously, they at least generously read alleged improperly neglected to bring a lawsuit. Enough to at least get past the motion to dismiss. The Supreme Court, happily for us, decided otherwise. But what this case does, I think, just re-clarify is when do you file a motion to dismiss, when do you file a motion to strike. There's some good black letter law on that. Questions, comments? So number 3, I wish I knew what I know now when I was younger. Rod Stewart? No. Rod Stewart. Yes, Rod Stewart. Thank you, Laura. You're nodding. I trust Laura on music with that. Shocker. So Shirley P. versus Norman P. Again, another collateral estoppel case, an interesting one. So a judgment based on the preclusive effect of a prior judgment must, not can be, must be reversed. If the prior judgment is reversed, and this is the key, the reviewing court can do so in the first instance, right? So if the first comes up on appeal. So this case has some very sad facts, which I'll go through quickly. Defendant's convicted for raping his wife, appeals the conviction. Their divorce trial was stayed while the criminal case was pending, then the criminal case goes on appeal, and they have their divorce trial. The trial court gives conclusive effect to the defendant's conviction, and solely on that basis, he finds the defendant, not surprisingly, but solely, finds the defendant exclusively responsible for the breakdown of the marriage, and therefore gives the wife the lion's share of their estate. The divorce decision gets appealed, and while it's on appeal, his criminal conviction is reversed. So what happens? The main point is the reversal of the criminal conviction. Deprived of conclusive effect, you have to reverse the divorce judgment, even though at the time it was proper for the trial judge to have relied on it. Right? Now I had may in the second bullet point, may, and then must in parentheses. Ostensibly, the Supreme Court may set aside a divorce judgment under these circumstances. I really think it's must. The Supreme Court has a lot of case law, a lot of discussion there about why it's an appellate court's duty to do this in the first instance without just remanding it back to the trial judge. Certainly it was the case here because it was the only basis for the trial court's award. Now this leaves unanswered the original question on which the Supreme Court took the case. When they originally took the case, right, the criminal conviction hadn't been reversed yet. It was just on appeal. They took the case to decide a thornier issue, which is what preclusive effect do you give to a judgment that is on appeal, where Connecticut, and I'll get this more taken, Connecticut and most states, the majority of states, say that the judgment retains its preclusive effect even though there's an appeal pending. Until a judgment is overturned or set aside, it has preclusive effect. And there's an appellate court case that expressly says that. But, I'm sorry, I think it's in other states. Connecticut, some states, the federal courts, that's the rule. Other states, if an appeal is filed and it's meritorious, takes away the preclusive effect of the prior judgment. So I think that the Supreme Court might have been trying to have the final word on Connecticut law about that, and any dispute. Probably, I think, say pending appeal doesn't deprive of the preclusive effect. So, what does this say? First, I think it shows the Supreme Court in part at its best, right? The obvious end to all of this was that the guy had to have a new divorce trial. Only basis for the divorce judgment was his now reversed criminal conviction. The court could have sent it back, could have given, could have done a lot of things, but I think applied a rule that makes sense under the circumstances. It's this obvious to an appellate court, they should just do it in the first instance. What does this tell, by the way, careful trial practitioners, not just divorce practitioners? Don't ever assume you have an ironclad case. Right? The plaintiff had other evidence that also would have supported a divorce judgment in her favor. She didn't put it on. Understandably, right? Her husband had been convicted of raping her. But it never hurts, right, to double ice the cake or triple ice the cake. If you have other evidence, even if it seems clear, put it on, backstop yourself just in case. Number two, so sunshine is the best disinfectant, and I apologize for the abbreviations. That is Commissioner of Emergency Services and Public Protection for Freedom of Information Commission. This is another lawsuit that arose out of the Sandy Hook tragedy. There, okay. So, and it has two separate bottom lines, one of which is sort of narrower and sort of FOIA specific. The other one, which although it's a FOIA holding, is I think very, very troubling, or possibly very troubling. So there's an exemption from disclosure under FOIA, except as otherwise provided by the federal law or state statute that makes a document confidential. Right? That requires the law or statute to expressly mention confidentiality or otherwise limit the copying or disclosing the documents for something to be exempt from FOIA disclosure. And this is, I think, the troubling or the broader part of the holding, so a privately created document can become a public record, subject to FOIA disclosure, simply because a public agency takes possession of it in the course of doing its job. So, this all turned on the Hartford Current, wanted 3 documents written by Adam Lanza that were seized by the police during their investigation of the Sandy Hook massacre. One of them was a diary. There was a chart that he made of serial killers, mass murderers, mass shooters, rather, and one other document. The department, the state police, refused. They said these are not public records. That's all they said about the record. Freedom of Information Commission holds a hearing, says no, they are public records, turn them over. The state police had other arguments they could have made about some of the documents. Didn't raise any other arguments. And the trial court agrees that these are public records, but says that the search and seizure statutes under which they were taken are an exemption where the law otherwise provides for non-disclosure, because the department has to return seized property if it's not used in a criminal prosecution. So, you know, somebody takes your car, doesn't get used, they have to give it back to you. What does the Supreme Court say? The Supreme Court reverses the trial court, and that's important in for a broad reason. I'll get to it in a minute. But even if the judge was right, they assume without deciding the judge read the search and seizure statutes correctly. The obligation to return seized property does not express confidentiality. It doesn't expressly limit disclosure or copying. And you have to construe all of the exemptions in FOIA narrowly, not just the enumerated ones. So for those of you that are not FOIA nerds, 1-210 has preamble language, and that's the language that was issued in this case. Then it has a list of subsections about what is exempt, things like attorney-client privilege, drafts, notes, memorandum. There have been some previous cases, looking at a footnote in a previous case involving petition of correction, that said it was just those enumerated subsections that you narrowly construed. This case has any exemption from FOIA disclosure is narrowly construed. And then the Supreme Court says, any document that comes into the possession of, in this case, the state police, is a public record, even if it was a privately made document. And in this case, the state police took possession of this as part of their investigation. So even though Adam Lanza created the documents, they are public records. So first, this continues the very broad reading that the court has taken of FOIA. To throw myself under the bus, the Harrington case they decided a couple of years ago, taking a narrow reading of the attorney-client privilege exemption and a broad reading of disclosure requirements in FOIA. Something that expressly limits disclosure, copying, makes things confidential, versus the federal rules of civil procedure, which just provide a mechanism under the discovery portions of the rules to have a sealing order, to have a limited disclosure order. And so, unless the law is expressed, like copyright law, it's not a FOIA exemption. And then, of course, when or how does a public record become a public record? Right? If you think about all the situations in which investigative agencies in the state take possession of materials, documents, privately created documents, they don't use all of them all the time. But those are all now subject to FOIA disclosure. Ann Catino represents, somebody who's trying to remediate a brownfield. And they have thousands of pages of documents that the Environmental Protection Department takes. Most of them don't end up being relevant in the administrative proceeding, but somebody wants to know what Tilcon, Connecticut is up to. If you read this case the way I think you have to read it, they have a way to do it. You file a FOIA request with Tilcon, right? Not with the department. You file a FOIA request with Tilcon, right? And say, listen, you have possession of this now public record. Give it to me. Okay. Last case. Wait. Yes. Thank God.
Going back to the whole search warrant aspect, that where stuff has to be returned to the owner when the criminal case is over with. In this case, the owner was deceased, so there was no place for it to go. If records had been taken by way of a search warrant and the owner was alive and the case was disposed of, would that impact this whole thing?
I don't think so. Adam Lanza had an estate, which I suppose technically was, he died in intestate, but he must have had an estate. His mom was his heir, he killed his I'm trying to think this through. I think that would be certainly something you could litigate and say, listen, my client's around. They have the right to this property. They don't want it turned over. But I think under the language of the search warrant statutes don't expressly provide for confidentiality. You're going to have a tough battle to try to get around the holding of this case, which is unless it's expressly in there, like it is in federal copyright law, you're out of luck.
Hey, Dan,
Yes.
I agree with everything you said in that case just now until the very end when you said that the FOIA request would be made in your example to Tilcon.
Right.
Tilcon's not a public agency.
That's a very good point, and I was wrong. Obviously, it would be made to the public agency that had taken possession of the documents. My inartfully made point was that Tilcon couldn't protest, right? Even though they have the documents back and are the owners. They could maybe ask or raise some other exemption. You know, these have proprietary information and whatever, but they couldn't say they're not public records because we created them and we have them back in our possession. But I think that's a very good point.
Yeah, and we've been involved in cases where the commercial entity has said, wait a minute, you have our records, but there's stuff in there that is proprietary, confidential, whatever. And we want the opportunity to take a first pass at those documents to redact anything that we believe to be proprietary, et cetera. And we've done that.
Right, so on that point, my experience is that you can get cooperation or not. This is Alan's experience to much greater length and agita than mine. On the Harrington case, we did a lot of attempted redaction. We thought we had a good argument, and the Supreme Court and the hearing officer agreed initially. Then the Supreme Court slapped everyone down, and redaction became a much thornier issue. But yes, I think that's certainly an argument you want to press on behalf of any client where there's stuff in there that falls under any other exemption. Listen, we're going to turn this stuff over. Just let us go through it. But right, I think FOIA is just a hotly litigated area right now because there are, mostly for better, I would say I'm a believer in open government. Mostly for better, sometimes for worse. People out there whose lives are basically just making FOIA requests, right? They're what used to be called gadflies, and they get some issue, usually local, sometimes a statewide concern that they really care about. Some unfortunately fall like the Nancy Burton category, but some are well-meaning and really care about stuff. Some, of course, are reporters. A lot of what you find out nowadays in the news is because the AP or the New York City filed a freedom of information request. But the truth is that when you represent an organization, whether it's a public or semi-public entity, whether it's a company that's had documents taken by a public agency, you have to think about the possibility that somebody's going to make a FOIA request about it, and how can you sort of proactively deal with that. I think the Supreme Court still, it's probably fade a little bit over time, is still very sensitive about what happened a decade ago, with all the issues about super secret divorce files, openness in the courts, and so they still are bending over backwards to say to the public, we are a transparent agency, and we're going to make sure that the rest of the government follows our lead. So we do want to call Saul. This is, without a doubt, the most important case of the year, although it is a criminal case. It announces a new state constitutional protection that differs from the federal constitution. So the state constitution, unlike the federal constitution, requires police officers to clarify suspects in an ambiguous request for counsel before they can continue with the interrogation. As a PowerPoint differs from the federal rule, which is that the police have to cease an interrogation only if a defendant is unambiguous and unequivocal in his invocation. And it is rare. In Wes, my beloved former partner notwithstanding, it is very rare for the Connecticut Supreme Court to say our Constitution goes beyond what the federal Constitution does. They do it very occasionally. Usually when there's state constitutional litigation, it's because there's something in our state constitution that's not in the federal constitution, like the Sheff case. There's no right to education in the US Constitution. There's an express article of the Connecticut Constitution. But for them to say our state constitution goes beyond is pretty rare. So the defendant's arrested for molesting his nephew. He signs a Miranda waiver. But during his interrogation, he starts mentioning his lawyer, who had been he had retained once the forensic interview of his nephew took place. So the police turn up the heat on them. They start saying things like, well, you know, you're going to have to register as a sex offender in the neighborhood. You know what happens to sex offenders in jail, all these sorts of things. And the defendant says, quote, if my lawyer was here, then we could talk. And I'm supposed to have my lawyer here, you know that. Trial court, not surprisingly given federal law, denies the motion to suppress because there was no unambiguous invocation of his right to counsel, and the appellate court affirms and rejects a brand new, had been raised in the trial court, argument under the state constitution that the state constitution should be broader. I will say here, this is an aside, this is an example of the vagaries of criminal justice depending on who you happen to get as an assigned counsel. In this case, the defendant was lucky enough to get Richard Emanuel as his assigned counsel. He never met Dick Emanuel. He was one of the most brilliant appellate lawyers out there, was a public defender for a long time. When he retired, he just took on full-time doing assigned counsel work as an appellate attorney. So he brings up this new state constitutional argument on appeal. And the Connecticut Supreme Court, unanimously, by the way, rejects the defendant's claim under the federal constitution, but says that Article 1, Section 8 requires a stronger prophylactic rule to ensure the state constitutional right to counsel. So the rule, if a suspect makes an equivocal statement that arguably can be construed as a request for counsel, the police either have to stop the interrogation, or they can ask narrow questions, but they can only be questions designed to clarify the ambiguous earlier statement. You can only start the interrogation again if the suspect, not the police, the suspect, clearly and unequivocally says, we can continue without my lawyer. The defendant's statements, obviously at the very least, were arguably a request for counsel. So the conviction got reversed. So what does this all mean? Well, first, it's amazing to me that this was unanimous, right? This would not have been unanimous 3 years ago when you still had Justice Espinoza and Justice Sorella on the Supreme Court. I think what it shows, again, is the center of the court, especially in criminal cases, coalescing largely around two people, around Chief Justice Robinson, the three people, but less so for Justice Palmer, he's getting close to retirement age. Chief Justice Robinson and Justice McDonald. This is Justice McDonald's opinion. Justice McDonald, surprisingly, because he wasn't ever a criminal lawyer, has written at least the majority of the important criminal cases since he came on the court. He and Justice Palmer, Chief Justice Robinson, that's basically the lion's share of them. And Justice McDonald has written most of the cases where they take an expansive pro-defendant view. So why did they do this? Because I think that's sort of what really matters. One is they did what the Warren Court used to do, which is they constitutionalized best practices for the police. Right? This is a practice that makes sense, right, in the terms of, frankly, good police work, and in terms of having, easier and more due process-oriented litigation down the road, right? If somebody wants their lawyer, they're supposed to have their lawyer, right? Don't pretend you didn't hear them. Don't keep going, right? Don't, hang your hat on the fact that, well, maybe he didn't really mean it, right? And this happened before, of course. The Miranda decision is the classic example of constitutionalizing a best practice for the police. And Connecticut did it too, right? A few years ago, there was a big debate about interrogations, should we record them or not? And there were some cases about it, and then it became law. You have to video or audio record all interrogations conducted by the police. And the police, at the time, the attorneys were up in arms about it, right? Kevin Kane went to the legislature, testified against it. Now, from what I understand, right, it's not as big a deal anymore, right? They're getting used to the practice, it makes sense, it spares them from cockamamie claims by the defendant. The cynical part of me says, they can figure out when they want to turn the record button on. Who knows what happens before that record button goes on. But in theory, it's smart police work. That's all that is. That's really all that this is. And I think what they wanted to make sure of is that there wouldn't be, let's say, below the belt sort of stuff around the margins of an interrogation. So they have these adverbs in there, arguably, clearly, unequivocally. So if you're a police officer and you play it straight in an interrogation, you'll be fine, right? If you don't, well, we've now put a thumb on the scales against you for what's going to happen in court. There is, for a multicultural society, language barriers, educational barriers, class barriers, the overwhelming power of police authority to a lot of people who interact more frequently with police than most of us probably do, right? And this is a protection put in place for them. Somebody's English isn't perfect, right? Somebody doesn't have, you know, a high school education, and somebody is just scared based on previous interactions with the police. This is there to protect them. And that's it. That's all I have. Thank you.
Thank you.